Hey guys. So for quite a while, I've been trying to access Parliament and communicate with Parliament because I felt like the Judiciary were in conflict with the Charter. And so just on September 9th, I wrote a letter to all the members of Parliament um, disclosing a breach of the Charter by the Executive and the Judiciary. I said, the judiciary is claiming they have absolute discretion and their discretion is not to be questioned and nobody has authority over them. The executive is supporting that unconstitutional role in the judiciary because they are similarly implicated. Now that the NDP Liberal Supply and Confidence Agreement has purportedly been torn up, it becomes reasonable to have this conversation in Parliament. I have suggested that it would be necessary to serve Parliament with the enforcement procedure of the Charter to properly check the judiciary, as there appears to be a breakdown in the formal procedures to accomplish that through the office of the Minister of Justice, but I choose to begin with this information. On August 28, 2024, I wrote to all the British Columbia members of the Legislative Assembly describing a failure in the rule of law and serious problems in the administration of justice. I attached that letter and many more in the attached PDF. Evidence for Parliament, so as not to repeat myself. I have also been in contact with Parliament on numerous occasions over the last few years, attempting to connect with an authority that would listen. I received almost no responses to anything, but I am confident that most of the parliamentarians have been informed through one process or another. I have been attempting to access Parliament to resolve a matter of national security for Canada, the integrity of its political legal system. Denial has been the ongoing solution, but it is causing more problems than it is solving. The Minister of Justice imposed martial law, enforcing the Emergencies Act upon Canadians, removing the democratic oversight of Parliament from the conduct of the Executive. David Lametti did that knowing that the Ministry of Justice was refusing to respond to a call for accountability through the enforcement procedure of the Charter, to bring the matter of judges through the Canadian Judicial Council claiming absolute and unreviewable power to the attention of Parliament, as the only court of competent jurisdiction to check the judiciary for Charter compliance. Furthermore, Lametti made false and misleading statements regarding his duties in order to protect his friends, other lawyers and judges, instead of doing his duty to protect the public. Accountability was being requested in the court system of British Columbia through a request for a writ of mandamus, a court order for a minister to do his duty. The claim by the Minister of Justice at the Public Order Emergency Commission that he was conducting himself in good faith is disputed by the evidence in my brief to the Federal Court of Appeal, but could be conclusively resolved if Parliament were provided the legal opinion that must justify that conduct. It is of grave importance for Parliament to assert its authority to check the conduct of the Executive in this matter. It is a matter of a guarantee. The Executive is improperly protecting the judiciary. Section 1 of the Charter, the Canadian Charter of Rights and Freedoms, guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The judiciary cannot justify that in a free democratic society, that they should have the discretion to ignore the transcript to protect a lawyer committing fraud on a court order. The Charter says, Section 7, everyone has the right to life, liberty, and the security of the person, and the right not to be deprived of, except in accordance with the principles of fundamental justice. Nobody in Canada is free and secure while the judiciary claim such arbitrary power. The unsupported opinion of the judiciary cannot overrule the best evidence that any Canadian could provide to prove fraud on the court. The Judges Act, enacted by Parliament in June 2023, has a declared statutory purpose. They say the objects of the Council, Section 61 of the Judges Act. The objects of the Council are to promote efficiency and uniformity and to improve the quality of judicial service in superior courts. The Canadian Judicial Council issued this response to my complaint. You complain that Justice Shaw accepted the evidence of your former spouse and her lawyer instead of accepting the transcript. You also complain Justice Shaw allowed a lawyer to not comply with the court order. The admissibility and weighing of evidence is a matter that falls within the ambit of judicial discretion. Chief Justice Pigeon is of the view that Justice Shaw exercised his judicial discretion when he preferred certain evidence over others. The exercise of judicial discretion is not a matter of conduct. The failure by a party to abide by the order is not either a matter of judicial conduct. As I pointed out in the BC Supreme Court on December 3, 2021, in my application for a writ of mandamus on the Ministry of Justice, I said, a judge that cannot determine the priority of evidence when presented with the transcript cannot be trusted with our rights, our finances, our lives, and our children. The Charter of Rights is an empty promise, our right to appeal is arbitrary, and the foundation of democracy is destroyed. Obviously, a legal system is very efficient when it ignores all evidence of misconduct by system insiders. That this ruling establishes the uniformity across Canada that judges may ignore the transcript to protect fraud is disturbing and unconstitutional and does nothing to improve the quality of judicial services except for hiding and protecting the judiciary in their misconduct and abusing Canadians as a result. Unfortunately, Parliament itself is implicated, with responsibility in this matter for allowing a judge that parliamentarians of all political parties, united in their disapproval, wanted dismissal, but everyone fell into line on February 2, 1999, when the Liberal Minister of Justice, Anne McClellan, pleaded for Parliament to allow the legal system to self-regulate. It is another decision time to decide which way Canada will fall, to allow the judiciary complete free rein to declare war on Canadians, as Myron Thompson, MP of the Reform Party, stated on February 2, 1999, after Parliament permitted Judge Shaw to remain on the bench. I rise on a point of order. Based on an earlier decision of a vote in this House, may I recommend we close this place and let the lawyers and judges run the country. That is tempered by the more recent comments by Member of Parliament Riel 14, Bloc Québécois, on June 16, 2022 in the House of Commons during debate on Bill C9, the Judges Act. We must never forget that the judicial system belongs to the people and must be accountable to the people. We are merely the ones responsible for ensuring that the system is effective. I would recommend listening very carefully to the independent researchers in the academic field of judicial conduct, such as Richard Devlin, who appeared before the House and the Senate debating the Judges Act and provided professional advice, which was ignored, and the judicial opinion of what should be in the Act preferred over more impartial opinions. The Minister of Justice, David Lametti, was quite explicit before the committee on November 17, 2022. He said, "It's not only our department, but also the judges themselves who worked very hard on this bill." Canadians are watching Parliament very carefully for compliance with the constitutional imperative to create peace, order, and good government. The alternative is using force to create order, which is bad government, because it is not in the public interest and creates zero trust that our government has the consent of the governed, and that government of the people, by the people, for the people, shall not perish from this earth. Or, to put it in Canadian constitutional terms, Section 1, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. There has been no justification provided for the conduct of the judiciary or the executive besides claiming that their discretion is unlimited and a refusal for that discretion to be examined. Parliament normally allows the judiciary to decide these terms when there is not a conflict of interest. But in this case, when it is the judiciary and the executive that are alleged to not be in compliance with the Constitution, we know that nobody can be a judge in their own cause, and Parliament must resolve the conflict in the public interest. The lawyers at the Attorney General's office in British Columbia are now openly declaring that the executive and the legislature has no role to play in the judging of judicial conduct. The Constitution provides Parliament the power, Section 99. Subject to subsection 2 of this section, the judges of the Superior Court shall hold office during good behavior. but shall be removable by the Governor-General on address of the Senate and the House of Commons. Parliament expands on the elements required for removal in the Judges Act. Section 80. For the purposes of this division, the removal from office of a judge is justified only if, for any of the following reasons, the judge's continuation in office would undermine public confidence in the impartiality, integrity, or the independence of the judge or of their office to such an extent that it would render the judge incapable of executing the functions of judicial office. 4 sections. Subsection A, infirmity. B, misconduct. C, failure in the due execution of judicial office. Or D, the judge is in a position that a reasonable, fair-minded, and informed observer would consider to be incompatible with the due execution of judicial office. The test created by the judges to judge judicial misconduct was created during the Marshall inquiry. Is the conduct alleged so manifestly and profoundly destructive of the concept of impartiality, integrity, and independence of the judicial role that public confidence would be sufficiently undermined to render the judge incapable of executing the judicial office, and that judicial independence exists for the benefit of the judged, not the judges? It is therefore to be assessed from the perspective of the reasonable observer and in light of the public interest it is meant to serve, and more recently affirmed by the Judiciary in Cosgrove versus Canadian Judicial Council. Judicial independence does not require that the conduct of judges be immune from scrutiny by the legislative and executive branches of government. On the contrary, an appropriate regime for the review of judicial conduct is essential to maintain public confidence in the judiciary. The matter was succinctly summarized in the Chief Justice Annual Report to Canadians. Chief Justice Wagner, June 3, 2024, stated, "Justice is not just a service. People need justice. When they recognize that they will not have access to justice, that will jeopardize our democracy and the rule of law. We should not underestimate this possibility. That is why we have to facilitate access to justice." Chief Justice Wagner stated on June 13, 2023, that in respect to the judicial discipline process, it was not possible for the public to have trust, and scandalous, and must be changed. But the amendments to the Judges Act made in 2023 do nothing to restore trust, and in conjunction with the evidence before Parliament, is a betrayal of the public trust itself. Canada does not have an appropriate regime for the review of judicial conduct. We have an access to justice crisis because the administration is not in compliance with the law and the public is not being protected. Parliament is the last bastion for the protection of the public interest and the legitimate purpose and authority to check the judiciary for breaches of the Constitution and the Judges Act, their governing documents. The judging of judicial conduct is a matter of national security and should be done fairly and impartially to all parties so that it is constitutional. The Minister of Justice has a critical role in the judicial conduct process. The Council has no power to remove a judge from office, they said in Cosgrove versus the Canadian Judicial Council. If the question of removal is to be put before Parliament, it is the Minister who does so. Like all acts of an Attorney General, the Minister's discretion in that regard is constrained by the constitutional obligation to act in good faith, objectively, independently, and with a view to safeguarding the public interest. But the Minister of Justice is saying one thing and doing another, and clearly not in the public interest. David Lametti said on December 9th, 2022 in the House of Commons, "We can be confident that this bill strikes the right balance. Canadians can trust that their judges are making independent and impartial decisions, and at the same time they can rest assured that the judge's conduct remains subject to review. Ultimately, this will improve trust in the administration of justice, but with respect to individual judges, both with respect to individual judges and on a broader scale. It is essential to remember that our system of laws exists to serve the public. It operates because we have confidence in its legitimacy. trusting in the capacity of its members and mechanisms to administer justice. This is no accident, but rather the result of sustained and concerted efforts over time. Here in Canada, we are fortunate to have a strong foundation upon which to build. This requires ongoing attention, however, by ensuring measures are undertaken to safeguard public trust. And the current Minister of Justice, Arif Virani, is refusing to provide the legal justification provided to Prime Minister Justin Trudeau for enforcing the Emergencies Act. Senator Carrigan has called him to account and compared Canada's conduct in this matter with North Korea. The Minister of Justice could waive solicitor-client privilege, but chooses to hide from Canadians a decision which is either legitimate and legal or unlawful and unconstitutional. That was before February 27, 2024, before the Parliamentary Committee on the Declaration of Emergency. Combined with this evidence, in my brief to the Federal Court of Appeal, the public is left with the conclusion that enforcing the Emergencies Act on Canadians was a decision that was not made in good faith, it was unlawful, and cannot be justified. The Supreme Court of Canada is refusing to hear appeals regarding the enforcement of the Emergencies Act, declaring the issue moot, which is clearly not the case. However, due to conflicts of interest within that institution and the judiciary generally, Canadians cannot trust the institution because they preemptively sided with the executive from the start. The Federal Court of Appeal rejected my participation as an intervener because of the allegations of lawyer and judicial misconduct. But clearly they are central to the issue under debate. So how can the public have trust that the issues will be fairly and impartially resolved if we are being completely ignored and punished for speaking out against corrupt practices? Ultimately, Parliament too has a conflict of interest due to the decision in 1999 not to remove a judge. But there is now a chance to correct that mistake. To err is human, but principles are what constrain a society. I remind Parliament that the Public Prosecution Service of Canada withdrew their prosecution of me of Section 238, subsection 1 of the Income Tax Act, the requirement to file, in the public interest. A restoration of the public trust is required. Delay and obfuscation is not helping Canada. Transparency and accountability is required. I have provided some recommendations to consider. I'll leave you with this quote by constitutional law expert Peter Hogg. In a democracy, there is no such thing as absolute unfettered discretion. It is a contradiction in terms. Fraud and corruption are always the exception. The consequences are very clear. In the final analysis, who is on the hook if a judge screws up? It is the Prime Minister and the Minister of Justice. Canadians would welcome the appropriate democratic debate on this matter of national importance. In fact, it would be a constitutional imperative. Yours sincerely, Trevor Holsworth. P.S. When a single branch creates the statutes, administers them, and adjudicates disputes arising from them, arbitrary government results. Freedom suffers, and real democracy does not exist. It's a quote from Aaron Barak, the Chief Justice of the High Court of Israel, in his book, The Judge in a Democracy. I remind Parliament, all authorities agree that the right of petitioning Parliament for redress of grievances is acknowledged as a fundamental principle of the Constitution. It has been uninterruptedly exercised from very early times and has a profound effect in determining the main forms of parliamentary procedure. That's from June 18, 1947, by the Speaker, Gaspard, Fauteau, in Parliament. The Canadian Charter of Rights and Freedoms, Section 24.1, states, anyone whose rights or freedoms, as guaranteed by this charter, has been infringed or denied, may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. And I attached the following documents for the evidence for Parliament. The letter to the editor of the Valley Voice, July 1st, 2021, prior to my hearing before the court on July 16th, 2021, and my website, fundamentaljustice.com. My communications with the Canadian Judicial Council, the CJC letter dismissing the complaint of August 28th, 2007, the email to the Canadian Judicial Council complaining about the conduct of a member of the council, and the registered letter to the Canadian Judicial Council, Mark Giroux. I've been in communication with the following parliamentary committees: the status of women, the Human Rights, Justice and Human Rights Committee, as they're debating Bill C9, September 20th, 2022. The Parliamentary Committee on Public Safety and National Security, November 18th, 2022. Procedures and House Affairs, PROC, March 6, 2023. The Parliamentary Committee on Justice and Human Rights, Bill C, when they're debating Bill C40, the miscarriages of justice. My direct communications with members of Parliament. April 19th, 2021, with Ms. Atwin regarding the parliamentary petition for judicial accountability. October 22, 2022, email to Mr. Poilievre, leader of the Conservative Party of Canada. Email to Mr. Singh, leader of the New Democratic Party, December 29th, 2022. Email to my Member of Parliament, Richard Canning, NDP, requesting Parliament be petitioned, June 21st, 2023. Email to the Shadow Minister of Justice, Rob Moore, October 23rd, 2022. Email to the Shadow Minister of Democratic Reform, Michael Cooper, July 13th, 2023. Email to the Speaker of the House, Anthony Rota, February 21st, 2023. Response of the Speaker of the House, March 9th, 2023. I was in communication with members of the Senate. Submission to the Senate Committee on Legal and Constitutional Affairs regarding the Judges Act, December 12th, 2022. Proposal for judicial reform submitted to the Senate Committee on Legal and Constitutional Affairs. Communication with the Governor General. I communicated regarding a minority government, October 26th, 2021, a month or two prior to the NDP Liberal Coalition Agreement. And I followed up that when I didn't get a response on March 7th, 2022. Never received a response. I communicated with the Prime Minister's office on multiple occasions. I submitted my evidence to the Public Order Emergency Commission. It was not submitted into evidence. I communicated with the current Minister of Justice, Arif Virani, on August 17th, 2023. In the British Columbia provincial jurisdiction, I had 2 registered letters to the Attorney General of BC and registered letter to Premier David Eby outlining the problem with the government not complying with the enforcement procedure and the Attorney General's claiming that they had no discretion to check the conduct of judges. I applied, after the Judiciary imprisoned me, I applied for habeas corpus to the Supreme Court of Canada, November 9th, 2023. More recently, in response to a request from the Canadian Revenue Agency, I submitted all the evidence. I have not heard back from them. And wrote directly at the end of August to all the members of the Legislative Assembly of BC. And they also included in that the my application for intervener in the Federal Court of Appeal, A7424, to review the circumstances of the enforcement of the Emergencies Act. And I included in there the constitutional question that I asked the Minister of Justice regarding his non-response to the enforcement procedure of the Charter and the income tax Section 238 requirement to file. And in the brief, in the intervener application, I also included some of the communications with the Prime Minister's office, as well as the Minister of Justice, David Lametti, where he made false and misleading statements. I responded to him and corrected him and never received a response. I contacted the RCMP, the National Division in charge of investigating corruption in members of Parliament, and they threatened to destroy evidence, asked me not to send any more evidence, that they would destroy it. And then I also included the Parliamentary Ethics Commissioner application to review the conduct of the Minister of Justice, which they never responded to me because I believe once they find criminal conduct, they cease all investigations because it's not within their jurisdiction. And then I also included in there excerpts from the transcript from the application for a writ of mandamus on David Lametti that was heard on December 3rd, 2021, before the Nelson Supreme Court. And a decision on that was due February 14th, 2022, when David Lametti enforced the Emergencies Act. And that is what's before members of Parliament for them to consider.